Today on DigitechToday Convo, we are joined by Georgina Giathi, an advocate of the High Court, certified data protection officer, and senior partner at WW Giathi and Company Advocates. She is a force in Kenya's digital legal space, known for leading major data breach cases and helping businesses across fintech, e-commerce, and more stay compliant with data laws. Beyond the courtroom, Georgina is also a respected mentor and trainer, having educated hundreds through eDigital Connect and the Hazina Foundation. If your business handles personal data, and let's be honest, it does, this episode is a must listen. Okay, so Georgina, thank you for making your time to be here.
Thank you for having me, Dan.
On Digitech Today. So, today we're going to be looking into data protection.
Yeah.
So, while I was just doing my research on trends in 2025, I noticed that data protection is one of the most highlighted topic when you're looking at digital marketing. And we've seen especially in the recent times, we've seen a lot of issues surrounding data protection because digital marketers, our content creators are consuming a lot of data in their day-to-day activities, executions, running campaigns, executing different activities in the digital realms. There is the use of data in many dimensions. What's your perception about, or what's your take on the issue of data?
Data is oil, and right now it's currency for digital marketers or for players in the marketing industry. So it is essential that as long as they're interacting with data, as long as they're processing data, they're held responsible for the data that they process. We have similar cases of other players in the SME field across different sectors, and we've seen this penalty levied in different amounts.
Mm-hmm.
Yeah, so I mean, it's if I'm to talk to any digital marketer out there, the data you process, you're held responsible for.
Wow, because I think there is always a bit of disconnect between the legal frameworks and when digital marketers are, of course, engaging with different kind of data. Let's say, be it images, be it the sort of things like emails, phone numbers. So what are some of, just maybe to a layman or to digital marketers, what are some of those some of the legal frameworks that they need to understand when processing data for their consumption? Because as you've said, data is all for marketers. So what are some of those legal frameworks, maybe just in a nutshell, that they need to understand?
The key frameworks that I'm speaking to those within the Kenyan jurisdiction.
Yes, of course.
I mean, it's important because there are frameworks in the regional sphere of things. Yeah. So okay, for Kenya specifically, we have the Data Protection Act of 2019. I think that's the primary point of reference. Then we have I would say that's the primary source of law for us as Kenyans. Then the secondary one, I would look at the regulations. We have the Data Protection General Regulations of 21. We have other regulations specifically addressing data controllers and data processors. We have regulations also addressing how complaints and procedures are handled before the ODPC. So I would classify the Data Protection Act of 2019, followed by the regulations of 2021. We have about 4 of them.
Wow, quite a number.
But if you just focus, if you're able to focus on the provisions of the act primarily, you should the regulations kind of like a supplementary to it. Then now, I guess now the next level of regulation, there's some guidance notes on the ODPC website. You're free to go check out on odpc.go.ke. They have publicized guidance notes for sector specific to guide specific sectors, and also general guidelines, particularly maybe on consent, on registration, on data sharing code that was actually shared recently. I believe towards the end of last year, early this year.
Mm-hmm.
Yeah.
Wow. So how now? I think you mentioned that different outlines of how digital marketers can get to look at it, and of course, you even mentioned they can also access some of this information on the ODPC website,
yeah.
which I think it's something I think most marketers probably don't take time to look at. And there's this thing I always say when you're entering to restaurants or like these public places, restaurant entertainment, joints, church, there is always that disclaimer. And I've always wondered, does it really cover?
Okay, the straight answer in as far as does it work in protecting you as a business
Yes.
from liability
Yes.
in terms of as a data handler. The straight answer is no.
Okay, interesting.
The straight answer is no. It's adopted. It's a standard practice. We've seen that actually most every event you go,
Yes.
there's that blanket disclaimer that as long as you've entered these premises, there's photographs being taken and it can be used for whatever purpose. Now the act underlines for most of these data handlers, let me generalize them as data handlers, that we do have data controllers and data processors under the act. But I'll just, for these purposes of this discussion, we can categorize them later in the discussion. Just for now, let me just call them data handlers. For data handlers, particularly, I would think for that particular example you've given, those are event planners, right?
Yes.
For event planners, as data handlers, what the grounds for which they're processing information is for purposes of, it could be for promotional purposes, it could be for any other purpose, but the grounds for which they process personal information, right from your name to your perhaps email address, phone number, when they're asking you maybe to register for a particular event, the ground for processing that, ideally, it's usually based on consent or legitimate interest. There are several grounds to process personal information, but specifically aligned to that particular example, I would say the one that we relied on a lot for them would be consent. And legitimate interest. Now, consent, the Act provides that it should be explicit, informed, and followed up by an affirmative action, meaning verifiable. In fact, we've seen cases. We recently did a determination analysis of all the determinations that were done by the ODPC as at the whole of last year, 2024, and we came to come across one against an entity. I don't know that she'll state the name here.
Yeah, you can state the name.
Oxarakasi Trust. They hosted an event. Just like we have, we have events every other time, right? We even have concerts in Nairobi. Let me speak for Nairobi, but even in Kenya in general. So for this particular event, a photo was taken, and actually they did put that disclaimer, the one you've just alluded to. The one of, this is a photograph. When you enter this area, this is you'll be taken.
Zone.
Yeah, it's a photography zone, and they used one of the photographs they took of one of the, let me call them clients or customers who attended that event, and they ended up using the same image for a different purpose, to promote a different thing. With still, it is them who took that photo in an event, and they used the same photo to now promote something else that they were doing. And of course it came to the attention of the owner of that image, and they made that complaint. And once it got to the ODPC's attention, it was investigated upon, and of course now the company they came forth and they said, but we put that disclaimer, we put that is a photography zone, and the ODPC held that is not enough. Why? Because consent it should be followed up by an affirmative action.
What do you mean by affirmative
action? I mean something that you can verify, because a consent is delivered by a data subject. According to the Act, a data subject is an individual. So you can't put a blanket kind of a disclaimer and then say that the individual has,
which is more general.
Yeah, it's very general. Yeah. So it would be better to, if the company managed to verify or like to get a specific consent that tracks to this particular individual saying that I have agreed, then that would be different.
Okay. So, well,
or rather, the outcome would have been different. Sorry.
Yeah, interesting. So let's say, so how can, of course, the people interested in doing, getting those content, like the photographs, the videos, most of the time, like, they're supposed to be used by marketers, right? Because after, it's more of like a post-event, a post-event documentation, communication. So it's used by comms people, the marketers. So how can they now really ensure, let's say for the events, how can they ensure that they get proper consent from these people so that it doesn't land them into problems?
Right. I would advise one to take a layered approach. A layered approach is what I mean. For example, in the case of that event, what more and more companies are now adopting to is having people register virtually. That way you're able to procure that consent, that specific informed consent from that particular individual. What I mean is, if you have already a privacy policy in place as an organization, and you procure, when you're appealing to your clients to sign up for an event, and they do so, and you can be able to integrate your policies. You can be able to integrate the requirements under the Act within your policy, through which your clients will interact with prior to their signing up. For example, we have some companies, what I advise is you embed consent forms. It could be a separate documentation, or if that is maybe perhaps tiresome in terms of getting that particular individual to sign up on a digital form, then what more and more institutions have adopted is there is this embedded, let me call it a consent tick box.
Yes, I was actually about to ask that. That one has also seemed a bit more seamless in getting that consent. But where the trick is that before, you should be able to design your website or your trading platform in such a manner that before someone is exposed, or before the user is exposed to that tick box, they first get to interact with your policy, where you cover your back in that sense. Then now expose them to that tick box. Where the danger is in automatic tick boxing. Yeah. Because it's not informed, it's not voluntary, it's not specific. It's kind of like you doing what the data subject ought to do, and yet it's not only your obligation, but it's also their right. So if there's an automated tick boxing, let me call it tick boxing in that sense, then you are already in breach. That is not consent. The same way a blanket notice is not consent, an automated tick boxing is also not consent. So of course now that it should also be like optional. Not because you see sometimes when you're probably maybe you're buying the ticket, so before you proceed to check out, probably they tell you to take to consent, like you can be taking photos. So it should be, at least it should be optional, so that it's not mandatory.
Yeah, it's not mandatory. Actually, there's a provision on the what we say by maybe explicit and equivocal consent. It basically means I am not forced to agree to take photos to have my photos taken, for example, whereas I just want to maybe attend your event and have fun and go home. I don't have to come to events, go before some kind of a board, perhaps somewhere to promote perhaps your brand and have a photo taken. It should still be, consent should be voluntary. It shouldn't be you're forced to give this so that you can access these services.
Okay, I get it. What about let's talk about like more of these primary data, whereby, for instance, you visit visit an institution or or a entertainment place or the or restaurants. So there is always that bit of, for example, maybe you need to access Wi-Fi. So and one of the things is that for you to access, you have to make sure to dine in. That means you have to feed in your personal data, and that is normally like they are forcing you. It's mandatory for you to feed in your email, phone number, so that you can now so that you can be allowed to use the Wi-Fi. So how about that? How and then immediately, probably the following day, you start getting promotional messages. How is that as well perceived in terms of?
That is already in breach. Okay. I mean, if you said it's a hotel, right?
Yeah, let's say a hotel, because most of them are actually hotels.
Yeah. If that hotel they haven't maybe read to you what their privacy policy is, or they don't have something on the wall where you can scan and access that information. If they don't have any measure in place, they're already in breach, because okay, first and foremost, if they disclaimed to you that for you to get the Wi-Fi here, you have to give us your information, and with that, and let's say you don't question it, you just go ahead and give it to them, and they process it, and collect it, and they store it, because there's a lot that goes into obligations behind processing and collecting and storing and transferring and deleting of data. It's a whole cycle. And if an entity doesn't subscribe to any of it, right from the point of collection, yeah, they're already in breach. They're already in breach. In fact, for that, I would say proceed to access the Wi-Fi at your own risk. Because if they go ahead and collect, you haven't consented, but they go ahead and collect, which is information they had told you prior. That is at your own risk. But on the entity's side, on the hotel side, they're already in breach. Yeah.
So I guess then there are so many risks involved with this, and probably for guys who are in advertising, what are some of those? I know there might be many. What are some of those that you've handled? Probably some of these issues. What are some of those risks in data protection, especially for guys in digital advertising, because they are the most consumers of data?
Yeah. I would say the key risks posing to such players is there's a third party risks. By that I mean, let's say you're an advertising agency or a marketing agency, and of course you collect information perhaps through email when you're conducting, maybe through it's called email marketing, or
email marketing,
or your paid ads where you collect personal information. Now, if ideally you collect and you store this information, right, for continuous use, for your marketing, for your promotional purposes. So now, if you collect and you store, where do you store that data? Most of the time you find more and more entities now use third-party security control vendors, right? Like, for example, you might end up using a cloud security.
Cloud storage.
Cloud storage, security storage, or you purchase perhaps from another third-party vendor.
Okay.
So if you're having a third-party, or if you're purchasing third-party tools to secure this information, you're exposing this information belonging to this particular person again to risk. So there's something we call third-party risk management, meaning as you follow the data, where the data goes, right from collection to processing to storage to transfer and so on. You look at where does this, once we collect, who handles the collection? How is it? Is it automated collection? What are the measures surrounding that automated decision making? Then right from now when data is at rest at the storage level, which third party have you engaged with in securing this information, and have these third parties complied?
Also, there needs to be compliance as well with the third parties.
As well as the third party, because if they don't comply, you also haven't complied. It's that liability automatic. As you as a data handler, that liability automatically transfers to you. So that's why we advocate for covering your back as an organization or as a marketing agency or advertising agency. Cover your back such that not only should you inform your client that we actually this should be captured in the policy or privacy notice. If your privacy policy is comprehensive enough, it should be able to shield you from a number of things, especially where you're being transparent with your client and you're actually informing them that, you know what, we don't have the. When we're storing data, we are not the only ones with access to your data. We've actually involved a third party in securing your data. And of course assuring them that because for your clients, the primary tool is trust. So if the third party hasn't obtained the security measures, then you as the data handler, you shouldn't have any business even contracting them, because that will put you at risk.
Okay.
And you find that most of the time the data handler won't go after, your client or your customer, they won't go after the third party. It is you they will go after.
They go after.
Yeah. So, you're the custodian of that data.
So I think there is a lot of, as a data handler, which probably mostly it's like when you're looking at this, in our context, these are the digital marketers, probably, of course, who stand in for the different organizations or companies they work for. And so what are some of those, now as a data handler, what are some of those responsibilities that have been bestowed upon you, probably looking at the Data Protection Act? What are some of those responsibilities? Of course, you've talked about, ensuring that the security of the data
that's being processed
is being processed. What are some other responsibilities that digital marketers need to know they are responsible for?
I think at this juncture we can call them data processors, because that's what they are.
Yes.
The difference, I generalized them initially calling them data handlers, but we have data controllers and we have data processors. Okay. So let me just outline the difference quickly as we move into the obligations for our data processor. In this case, they are digital marketers. As an agent or as a running agency, I'm speaking specifically to digital marketers, right?
Yeah.
As a digital marketer, you're running perhaps an agency. You're basically ensuring that your client has exposure in the digital space, and that way they generate revenue and so on. So ideally, you are a data processor. What that basically means is you have, I wouldn't call it mandate, but you have instructions from a data controller to collect, process, store information. But what you don't have control over is how that data is used. Whereas for a controller, for your client, let's say it's another company that engages you as a marketer to push this particular service or this particular product, they ideally would be the controller, because they have control. I don't want to use the word to describe the word, but they ideally have the mandate to basically state how, when this data is collected and how they have more control over how data is called, how the data is called, because that information now trickles to the data handler. I hope that is clear. So yes. You as a data handler, one of the key obligations that you're tasked with is, number one, there's the registration bit. So look at, have you registered with the ODPC as a data processor?
So that is something
it's mandatory
to
actually.
Yeah. ODPC.
Yes.
Never known that.
It is a requirement under the Act. And the regulations actually specify the specific sectors, the compulsory sectors that ought to. They don't have an option. I think there are about 10 or 11 sectors. But what the spirit of that act ideally is, as long as you're handling personal information, you're held accountable for it. So you should be registered.
How many, let's talk from the Kenyan context. How many Kenyans are actually, like, organizations or companies are actually complying with that? Because that's something...
quite a number. You'd be surprised. I think if you're a listener right now, you can go to odpc.go.ke. There's actually a register of all registered data controllers and data processors. There were actually quite a number. And there was recently a directive to, of course, now not medical practitioners rather, but to hospitals and institutions that process health data, to ensure that they've complied registering as a data controller or processor by 31st of March this year.
So this year, by 31st of March. 31st
of March. In fact, from the date of recording, this is like what, almost 10, 11 days away.
Wow.
To the deadline.
That's interesting. I think then there is a lot of development that probably people are not aware.
Yeah, there's increased appreciation of this act, I must say. There's increased acknowledgement of the obligations that these entities have. There is we still have a long way to go in as far as more and more people are becoming aware of this particular act and its provisions and what obligations it imposes on each player.
Yeah.
But yeah, so ideally, after once you've registered as a controller or processor, then it's advised to ensure that your data cycle is well mapped out prior, because some of this information will be required at the time of registration. What I mean is, you should be able to identify what information are you actually collecting. This will even inform your policy, because that will also outline that. So identify what information are you collecting and why. Why are you collecting what you're collecting? And that should also be ideally communicated to your client or to the direct consumer. And then if there's a very specific purpose for which you're collecting that information, use it for that specific purpose. Don't use the same information for a different purpose without having obtained consent for that different other purpose. So it gets a bit technical, but I think mapping, it's called data mapping. It helps you as a marketer or as an agency to just understand. It's the whole data flow. It's what I'm calling data flow, or what other people may call the cycle. Yeah. Right from collection, what are you collecting? What purpose are you collecting it for? Are you collecting what is required? Because what we've also noticed is, it's called the principle of data minimization. Now you find you end up collecting more than what you really need for the purpose you need to achieve. For example, I'm speaking to digital marketers. For example, let's say your client is a pharmaceutical company and they're pushing a particular medical product. Let's say it's a cream to clear eczema rashes. For example. Now, if you're pushing that particular product, ideally what you may require is a telephone number of the consumer, right? A telephone number and perhaps the name of the person. But will you require ethnicity? Do you even require the nationality? Is it really important? Perhaps maybe when you're doing geographical analysis, but would you require their postal address? If it's not for delivery purposes, do you really require that? I mean, as long as you're able to meet the particular purpose for which you're obtaining information, stick to that. You don't need to get someone's next of kin. And yet all you're doing is pushing this cream that clears eczema rashes. Yeah. So the mapping is important. It informs your policy. It even informs how you go about the processing itself. Because if you're, because you can imagine, after you've registered as a controller or processor, it basically means you're on their radar.
Yeah.
If the office was to just look through the register,
Yes.
and see, let's pay this one a visit.
Oh.
So ideally, what I'm basically saying is, have a proactive approach to it, not a reactive one. Don't wait until things blow out of proportion. Don't wait until a complaint has been lodged before you, like I've mentioned about the Sarakasi Trust.
Yes.
Don't wait until it gets there for you to realize, okay, yeah, we need to comply. Just ensure that you have all these processes and all these factors already in play and embedded into your day-to-day operation as a digital marketer. Before anything was to happen, because it would be better. You would be in a better position to comply proactively than reactively.
So, talking of compliance, which is now the elephant in the room, do ODPC actually ensure compliance? For instance, most of the things we hear is from what is taken to them. Like someone goes to complain, and then now it's when we hear there are some institutions that have been fined, but does the authority really go out there to check if institutions or organizations are really complying with the when it comes to data protection?
What I can say is this. Like I've mentioned, there are those compulsory sectors. I think I can just mention a few. Hospitals are one of them. Educational sectors or institutions are others. Telecommunications are others. There's an entire list. Those are just a few of examples. Now, for those particular sectors that are actually compulsory, obligated to comply, we've seen the ODPC actually through their team. Through their team, they've actually paid some of these institutions a visit. Banks are another. Sorry, I forgot. Yeah, financial institutions are another. And sometimes it can be with or without warning. We've actually seen them do that. Those audit, they call it audit visits, basically to see how your processing activities are as an institutions, where there are gaps, where there are how best, or recommendations on how best to actually go about that, whether you're actually in compliance or not. Especially that's what an audit does. It kind of looks at what is how fit are you as an institution in processing the kind of information that you've been processing, and then rendering a verdict on how fit you are, depending on the processes, the strategies you have in place, the internal structures, organizational structures you have in place. So we've seen that with the compulsory sector. Now, on the other side, of course, it's not. I'm sure it will require a lot of muscle, financial muscle, for the ODPC to go through literally each and every registered controller and processor. So what ideally happens is, for most other businesses, for example, institutions that don't fall within that compulsory category, what happens is, now if there's a case or a complaint lodged before the ODPC, usually an investigation period for each case. They do that actually for each case. And now based on investigation is it's what informs the determination. If you actually look at the determinations that are again on the same website, you actually find that.
So on the website we can find some of the cases that have been
have been determined,
and the outcome, determinations.
Yes. Together with the guidance notes as well.
Okay.
Kama unapenda kusoma, head on to it.
Interesting.
But we're here to break it down for you.
Yeah, at least we're here to make it easy for those of us who don't like reading. And now you see, issue of third party. Issue of third party is also a major issue. And I believe also marketers, sometimes we interact a lot with third party, data. Because third party, more or less, you might find it's more of easy, like already someone has collected, so it's just you to get from the third party and make use of it. So what are some of those things, or what are some of measures a marketer should put in place when handling like third party data?
Part of that third party management, aside from of course ensuring that they have the security measures in place, and of course covering your back in that sense in your own policy as an agency. The other thing you should also the other thing, but you should really consider to adopt is the use of what we call data sharing agreements. Yeah. So data sharing agreements, it's basically really, I think it's just derived from the name. It's just a series of clauses that basically outlines or governs how you're going about sharing of that information to the third party and vice versa. So ideally, you should be able to cover your policy in that as well. You should also be able to outline what have you actually done to secure this information. How does your processing entire cycle look like? What measures are in place to secure this information? And what are you expecting the other person to also adhere to? Because like we've mentioned before, if you are quote unquote compliant, but there's a gap in the data sharing bit with a third party, then that liability transfers to you. So if you have entered into an agreement with let's say it's a vendor or a supplier or something, and they haven't been able to actually show you that they have complied, then you are already in breach.
That's already a breach.
Ideally, you should also be able to inform the consumer that this information will potentially be shared with so and so, and that ideally should also be captured in the same policy. That's why I keep reverting to the policy, because aside from privacy by design and using these technical measures and security controls to secure data, I feel like the governance bit is really backed up by that policy. So if a policy is comprehensive enough, you should be covered. If it's comprehensive enough, if you've covered all your bases, if you've covered all your bases, and as far as your grounds to process, you've identified your entire data cycle and what you've actually collected and so on. If you've managed to actually follow through the compliance roadmap, right to how to even destroy data, because ideally you shouldn't be processing the same information and have it in your mandate forever.
Wow, I think I like what you say. And when you're talking about even the issue of destroying like data at some point. So we see a lot when you're visiting, also like when you're visiting maybe a friend to another apartment, when you're going to office blocks, you're always being asked to leave our information with the security guys. And there has been sometimes sayings that these guys, the security guys, sell the data to marketers, to insurance people, because those are the ones, especially guys in the sales industry now as well. So they buy these data to use for their. So who is responsible for this data? Assuming you go and buy this data from a security guy, it's very hard for you to trace back and say I got it from so and so. The commercialization of personal information is actually an impending menace. Unfortunately, there is that selling of information, I would say, in the black market in Kenya.
Yes. when you ask on who is responsible, because for one, that is not legitimate processing, right?
It's not.
So right from the person who collected to the person who sold it to the person who bought it, you're all liable.
You're liable for it.
You're all liable for it. And unfortunately, sometimes it may be difficult to trace back, to the initial handler of this information. But eventually, if let's say you as a digital marketer, you've processed that information indirectly, right? Because you haven't collected it directly from the consumer, you still have that obligation. In fact, treat it as if you're collecting it directly from them, because the obligations are imposed. Because at the end of the day, you still process that information, you'll still store it, you'll still use it for promotional, for commercialization purposes, or to promote something. You'll still end up using it. So the same obligation will still apply. But now the ground for processing that will be based on consent, because the legitimate interest aspect is thrown out the window the minute you purchase that information in the black market.
That one is thrown out.
Not the way, you can't talk of legitimate interest when you haven't processed it legitimately. If there's no lawful ground to process it, the ground then to rely on would be consent. Yeah.
So and it's also important now. We know, of course, there are so many risks that comes with it. If you're not processing the data the right way or through collection. So what are some of those? And now I know also marketers are always interested to know what are some of the penalties involved. We know of the fines. You've said Oppo was fined 5 million.
5 million, yes.
For
basically using someone's image to promote their services or products
without their consent. So now, what are other penalties that can be, that a marketer or a data handler can go through a processor?
So aside from the infamous fines, the other penalty would be an enforcement notice. I don't know whether I can call it a penalty, but the other outcome of complaints lodged by the ODPC is an enforcement notice. What that basically means is it's where the ODPC, which is the authority mandated to oversee compliance, the basic, it's kind of like I can't call it, I'm trying to look for a layman's term for it. I can't call it a warning. It's not a warning. It's basically kind of like it's an order, not kind of like, definitely an order, just telling as an institution, do this and this and this to comply. And that normally happens, for example, where some of the cases we noticed where an enforcement notice was issued is where, let's say, there's an aspect called data subject requests. There's another side of it. It's a bit wide. What a data subject request is, we've talked of a data subject's rights being a data handler's obligation, right?
Yes.
So the data subject I'm referring to the consumer. Let me call them consumer or client. To simplify this.
Clear. So data subject is
data
like
subject is as a consumer. It's a natural person. It is you. It is the kawaida wananchi person that you pick the information from directly, not the ones you buy from black market. So a data subject request, is where these rights, they have a right to be informed. We've talked about you have to be transparent. Whether you're using automated decision-making tools, you have to be transparent and clear that you're actually doing that and inform the customer that you're doing that. If you are transferring their information to a third party that we've mentioned, you have to also inform them that, this information you're collecting, we're not the only users. We're actually transferring this also to this third party. You can identify them. Of course, to secure your customers' trust, you have to also indicate that there are measures you've taken in place to ensure that this transfer is safe and all that. They also have a right to have their information deleted So they can make that request for you to delete through what now? It's what we're calling now the data subject requests. There's a data access request as well, meaning if they want to access the information that you have, you should be able to give it to them. If they want you to delete the information you have, they should be able to request you to delete, and you should be able to actually delete them within a specific time frame.
So even if they actually give you, they consented you to have it, they can be able to just tell you.
They can withdraw it. They can, in fact, you should be able to inform them. You know what? The same way you have consented, you have a right to withdraw this consent. You should actually inform them. Ideally, you should be informed them. And now, those data subject requests is usually time bound, like what I've said. Like if a client wants you to delete the information, you should be able to do them within a very specific timeline under the Act. I believe the timeline is either 10 or 14 days. So if you don't, that's a breach. So where the enforcement notice comes in some of the cases we've seen, is if the data subject requests to either access, delete, transfer, rectify, because that's also a right. Then if there are cases we've seen where those requests are made, the receiving entity fails to meet those requests within a certain period, but by the time the matter is, before the ODPC, they actually go ahead and accommodate those requests. Those shifty scenarios. So like the timeline has passed, but by the time the matter is now before the ODPC and it's almost at the determination stage, it's actually upon the investigation stage, perhaps it's realized, this request was made maybe several months ago, but you guys actually did this 2 weeks ago. So in some of the cases, you may find that sometimes the ODPC is lenient in a bit by giving you that enforcement notice, basically to tell you that you may have some of these measures in place, but you're still in breach in this sense. So why don't you go back to the drawing board and cover these gaps so that you remain compliant. But those are I would say those are very lenient cases and not so many cases. Not so many.
And probably they are normally not of high magnitude, probably. Or you find that sometimes you may find it's a repeating offender. A company notorious.
Very notorious. So you find that where a company was, or rather an entity was already levied a penalty for the same issue in a different complaint, and then a similar complaint is lodged with a different complainant over the same thing. You find that the second time the office could be a bit lenient. Either that or the vice versa. It could be that the first time was an enforcement notice, but since they were sent back to the drawing board and ensure compliance and they failed to do so, and there's now another complaint, then it's a penalty. And a heavy one.
That brings me to another question. You see, also issue, let's talk of AI. AI generated content, AI generated, nowadays people are generating content. And sometimes I was hearing rumors that there were some people who actually even wanted to, demand right for ownership for AI generated kind of content.
Images or content.
How is that like related in terms of, can someone really own AI generated data, let's say images, videos? Can someone really say like, I own this data, and they can actually like sue you for that?
There's a contention on that. I believe it was 2023, where the US actually gave a stance on AI generated images and who owns these images. And the stance, or rather adopted stance on that has been, because that goes to image rights and intellectual property rights. The stance on that has always been an AI generated image doesn't belong to a human being. It's
not even
it
human.
doesn't. It's not even. Yeah. It can't. You can't own it as a human being.
Yeah.
So even enforcing that right may not really be viable. And actually, I think now there's a gap there that more and more institutions are actually adopting, in the sense of that they'd rather use AI-generated images. We've actually seen a lot of even the big companies in Kenya doing that on their billboards. You actually realize that this image is actually not of a real person. It's AI. You've seen that, I think, on you as you're driving up, especially on the main highways.
Yes,
it's a gap that institutions are of course exploring, and of course it's budget friendly and all that.
Yeah, of course you're avoiding paying.
You're avoiding getting
of people. It's expensive.
Yeah, paying models, paying videographer and photographer and so on. But in as far as image rights go, and in as far as moral rights vis-a-vis image rights, because it's a whole discussion. But the stance since then has always, different jurisdictions have been adopting a different school of thought regarding that particular issue. But the stance that I believe is also what is also the stance in Kenya, although we are still in the mode of regularizing ethical use of AI in Kenya. I think you saw this. The Ministry of ICT and Digital Economy released a draft AI strategy for Kenya earlier in January this year. So we are still trying to shape and regularize and regulate rather this particular space. But the stance is AI generated images cannot be enforced as an image right. As intellectual property right.
Yes, right? Because I think it makes sense because they're generally they don't have any. They're not connected to.
Yeah, you can't trace it back to a human being.
So as we probably wrap up, what are some of now? We know all those challenges. The penalties that can come with misusing data. So what are some of those best practices? Probably some of the simplest, probably a marketer can use, or business owners can use, or can put in place to ensure. Let's say a normal marketer or a normal business owner, they don't want too much complicated processes. Just want, I can get data from customers and I can use it. So what are some of those simplest ways to ensure that you're compliant?
I think the best place to start, just be clear on the grounds you're processing the data on. Just be clear on that. I think it's a good place to start from. Once you're clear on the grounds for which you're processing information, of course, after identifying what exactly you're collecting, once you're clear on that, it will inform a lot of things, including how you even embed or integrate the security controls if you're subscribed to them, how you integrate the policy that you'll of course need to form. You can't escape that. It will inform a couple of things, including how you can operate on a day-to-day and remaining compliant. Once you're clear on the ground on which you're processing data on, that's a good place. That's a good footing. The other thing I would say is ensure that, especially for digital marketers, particularly I'm addressing this in particular to email marketing and use of WhatsApp and SMSs. Ensure you have clear opt-in measures and clear opt-out and functional opt-out, because we've also seen a case where an entity has all these things in place.
But they don't have the opt-out.
No, they have the opt-out. They actually have the opt-out, but it's not working.
It's not working. Yeah, you try to, because there are some instances where you've tried to, you are in an email marketing, like you get email promotions.
On an email list.
Whenever you try to unsubscribe, you're still
very much subscribed and getting every information that you've got. And you see, if that's the case, the entity is in breach. Because at the end of the day, if you have all these systems in place but they're not working, what are you doing?
Yeah.
So I would advise be clear on the ground you process in, or the ground you process a personal information on. Be clear on your opt-in and opt-outs, because that should be very clear. Be clear be clear on how you obtain consent, and it should be followed up by an affirmative action. It should be verifiable. And I think that the last bit I would state is internal screening or auditing from time to time helps. Auditing or internal, what other people call it, internal screening. Basically, just look internally. Like we've said, if you have all these procedures and measures in place and none of them is working, or if they are working until to a certain extent, you're unfortunately still in breach. So ensure, if you have systems in place, good, very nice. Now ensure that these systems are actually working. Ensure the consents are actually visible on your platform. Ensure that your policy is actually updated to reflect your processing activities. Because again, if it's not updated and a complaint is lodged on something that is not captured in the policy, you are again exposed. Like, ensure you have these systems in place, and after having them, ensure those systems are working.
Okay. Wow, so I think it's all about like having more of a structure, structuring your data collection and ensuring that you can stick to it. And also the auditing part is very nice, because your internal screening, you can be able to see where there are gaps, and of course now work on the gaps to ensure that you're not missing out. And I think also it's also good to keep abreast by looking at what's happening in the industry in terms of reading some of those determinations like on the ODPC platform. So now lastly, on your last remark, probably what's your planting shot to the digital marketers or small business owners, and talk to them?
To digital marketers and small business owners, I think this one will cut across. Data is digital currency. It's your tool of trade, and customer trust is the most viable and the most viable resource that you have. So protect it, guard it, because the data you process, you're held accountable and responsible for. I think that would be it.
Wow, thank you so much for sharing.
Clear into the point.
It's been insightful, man. I think I've learned a lot as well. And we look forward to having more follow-up discussions on data protection, because data protection right now is a big discussion. And of course, by marketers getting to know some of the discussions that are there, that are supposed to know, to help them make their marketing effective and more easier to avoid some of these penalties. Definitely will have this more.
Absolutely. I mean, if there's an opportunity to save money and your reputation as a digital marketer, why not take it?
Absolutely.